Well, civil rights organisation Afriforum has lodged papers at the Constitutional Court to challenge the regulations of the State Capture Commission of Inquiry. Now, the most contentious being Section 2, which prohibits the use of evidence given during the inquiry in a criminal. Well, legal experts argue this essentially exempts implicated parties and by extension undermines the rule of law. Afriforum's Willie Space joins us now from our Pretoria studio. Good afternoon, Willie. Thank you so much for sharing your time with us on the SABC News Desk.
Good afternoon.
Willie, you're worried that the Commission will be rendered toothless almost by this particular regulation. Just put it all into context for us and talk us through what this section entails exactly and why you're uncomfortable with it at this point.
Well, we know that this Commission of Inquiry is the result of the report by the Public Protector 18 months ago, just before she stepped down, and her proposal as a remedy as a result of the State of the Capture report was that this commission should be appointed. It should be headed by a judge proposed by the Chief Justice, and the commission will have to interrogate individuals, make sure that the facts are found, and then the commission will have no lesser powers than the Public Protector would have had were she in the position to continue with this investigation. Zuma challenged this, and he failed in his challenge, and the Pretoria High Court ruled in December that the Public Protector's report is not reviewable, that the Commission of Inquiry had to be appointed. And then Zuma did it, and we know that Deputy Chief Justice Zondo was appointed, and he has to start off with his work. This specific regulation that we are concerned about has the effect that it actually takes away the power of this commission to hear evidence and afterwards to make a proposal that, based on the evidence that was heard, criminal proceedings should follow, because any evidence that's been laid before the commission and any facts that come to light as a result of the evidence before the commission will be inadmissible in subsequent criminal proceedings, according to the mandate that the President has given. So we know that as a result of this, it will be a toothless commission. It will be a commission that can listen what has happened, it can identify people who did wrong, but it can propose no remedies that actually ensures that accountability applies, that people are being brought to book, and that justice prevails. And for that reason, we think that Zuma overstepped. I think he has gone too far, and he actually preempted what courts should have done, and that was to decide how to deal with this further. And based on that, we are asking the Constitutional Court to set aside these regulations or the specific regulation in order to carry on, allow the Commission to carry on without the burden of being actually handicapped as a result of this very specific limitation.
Willie, you've submitted this as an urgent application to the Constitutional Court. Has a date been set down yet for the court to hear this matter?
No date has been set out. The application was issued last Friday, or this past Friday. Obviously, in terms of the Constitutional Court rules, the respondents in the application now has time to indicate whether they abide by the application or whether they intend to oppose it. We'll have to see whether the President or the Public Protector decide to oppose. I'm not sure what they will be doing. If they do that, they will also have to substantiate their opposition if they oppose with an affidavit stating the reasons why they do not agree with our view or with the prayers that we are asking for. And then the Chief Justice will issue directives according to the rules of the Constitutional Court for the matter to be heard, to be argued, and for the court to be in a position to deal with it. It's also possible for the court to make a ruling just on the papers before it, and we will see within the next 3 weeks or so which way this matter will develop.
Vali, we are running out of time, but I have to ask you this before you leave. We just heard President Cyril Ramaphosa, in his reply to Sona in Parliament, speak of expropriation of land without compensation around that issue. And he was at pains to say that this will be a very well-managed, well-controlled, and it will be done in a very sensitive manner that does not hamper food security. I just want to garner your initial reaction to the President's statements in Parliament this afternoon around the land question, which remains a very emotive issue in the country right now.
To take property without compensation or without counter performance is stealing. The allegation is that land was stolen years ago, centuries ago to put it that way, and the quick fix that President Ramaphosa is proposing is actually to take it back without compensation. In other words, to steal it back. As far as I'm concerned, that does not make sense, unfortunately. The Constitution is clear that when property is expropriated, it should be done with compensation being paid. There are mechanisms that can be used, and it's a pity that government has taken this route, and it's a pity that President Ramaphosa has embarked upon this road. Obviously, we are not on the same side in that regard. If you destroy property rights in South Africa, you destroy the economy, and the poor and the vulnerable people in our community will be even poorer and even more vulnerable. Because by taking property without paying for it, you are not improving the problem, you're worsening it.
Willie Space, I do wish we had more time to chat around this matter. That was Willie Space, the legal representative of Afriforum, joining us from our Pretoria studios. Thank you for sharing your insights with us on the SABC News Desk.